but a coma from which she was never expected to recover. After all that point where she went to the Supreme Court, they went to the Supreme Court, they got the permission to turn off her respirator. They did turn off her respirator. She also had a tube feeding. They continued to tube feed her, and she lived for 7 years after the respirator was turned off. Okay? So you shouldn't just think about, okay, I'm terminal, which our statute defines as 1 year. I'm going to die in a year. Because there are other end-of-life issues you might want to discuss. And things like the 5 wishes document can help you get through that. So you have that conversation with yourself, with your family, and then with your lawyer, so it's lined up with the documentation. Now, trust-based plans. You all heard about them, living trusts. I do a lot of them, okay? I think they're really cool things. But let's talk about how they're different from the traditional plan. The traditional plan had the will as the primary document to pass your estate. The trust-based plan has a living trust as the primary document to pass your estate. You're still going to have a will with that. Now that may seem kind of funny. What this will does, it's called in the lawyer talk a pour-over will. We're going to call it a pooper scooper. Okay? So what it does is it says, anything that isn't in my trust when I die that has to pass under this will, have the will clean it up and pour it into my trust, and then let my trust handle it. That's what the pour-over will does. And you need one with a living trust just in case you have something that isn't in the trust when you die. Maybe we didn't get it all in the trust before you died. Maybe you forgot something. Maybe you inherited it from your great-aunt Minnie before you could put it in the trust. Maybe you did the Waking Ned Divine thing and you won the lottery and died. We got to deal with those situations. Now, you're still going to have a power of attorney in the living trust-based plan. Your legal and financial power of attorney is primarily for assets that aren't in the trust. Things that will never go in your trust while you're alive, like your IRA, your 401k, your annuities. Those all have to stay out of the trust while you're alive. So you've still got to have somebody named to manage those if you can't. And the trust is just about stuff. It's just about money, things with a dollar sign attached. So you've got to have a medical power of attorney and a living will, even when you have a living trust-based plan. Now, remember what Peggy said I told her when we first talked? I do the paper. Can you see that there's a lot of difference between the paper here? Everybody almost always ends up with a will. Some end up with a trust that comes into effect when they die. Some have a trust when they're alive. They all have the other kinds of documents. So don't get caught up in the paper discussion. What you need to share with your lawyer is what you want to accomplish, and they'll tell you how to get there. So you're sitting around here going, well, I still don't even know what those things are. A will is a set of instructions for the probate court. It tells the probate court what you want to have happen at your death. It's only effective upon your death. It does not help in the event of your disability. It's all about planning for your death. It only deals with your property, except if you have minor children, and it deals with naming a guardian for them. I guess because under the law they were once property. I don't know. And then it tells them how to pay your bills. It really just says, make sure you pay my bills. Okay? And then distribute whatever's left after my bills have been paid to these people in this way. That's what a will does. So a will is really a ticket to the probate court, because whatever is controlled by your will goes through the probate court. And I get a lot of people who come to me and say, I want to avoid probate. And I ask them, well, what do you think probate is? And the answer I get is, I don't know. Well, then how do you know you want to avoid it? Now, the truth of the matter is, in a lot of our planning, we hope to avoid probate, okay? But only because it's icing on the cake. We can accomplish everything else you want to do, and if we can avoid probate too, hey, why not? But don't consider avoiding probate to be the tail that wags the dog. You want to get where you want to go, and then you just decide whether probate's worth going there. So what is it? It is the court-approved transfer of assets of a dead person. So it's just a process where someone, the person in your documents named the personal representative, has the authority granted to them by the court to collect your assets, pay your bills, and then transfer your assets to the next person, okay? Because you know what? Once you're dead, you can't own anything. So we've got to have a process to show, well, how do we get it to the next person who's going to own it? And how do we show that that was done with the authority of law? And that's how the probate process has come to pass. Now let me just share something with you, though. Our legal system, long before we were a country, but the history of our legal jurisprudence had probate long before we cared who got the property. Because in Britain and in France, where we get a lot of our legal history, we already knew who got the property. It was the oldest son. That's called the law of primogeniture. And there was no question who was going to inherit. The reason probate was developed was because somehow the oldest son was getting the property and the dead guy's bills weren't getting paid. And the creditors didn't like that process at all. So they developed probate to make sure the creditors got paid before the oldest son got anything. So that's where probate came out. Okay? So if you have a will and you have property that will be passing through the will, you will have your assets go through probate. Now, before we talk about a trust, let's talk about what property does pass through a will. Property, remember what probate is? Probate is the court-approved transfer of assets of a dead person. So the way to not have probate property is not have anything that you own. But there are different ways you own things. Okay, and we're going to talk about this towards the end of the program too. But if you own it in your name, right, and only your name, it's going to be probated. If you own it in someone else's name with you, so there's two of you or more, it may be probated. It depends on how you title it. It could be titled in joint tenancy, or it could be titled as tenants in common. If it's joint tenancy, that means the last one standing gets it. Doesn't matter what the will says. Whoever on all this list of people who are owners, who are joint tenants, the last one who's living, that's theirs. And all I have to do, if I'm the last one standing, is file the death certificates of all the dead people before me, and it's mine. I don't care what their will said. In joint tenancy, the will of every person who owns it will control their share. So if Peggy and I are tenants in common, I think that's what I said, tenants in common, then I own half and she owns half, and I can do what I want with my half in my will, and it will pass under the probate court. There's a lot of other things that won't pass under the probate court. Life insurance, for example. Generally, you have a beneficiary of your life insurance. Then the beneficiary gets it, no matter what your will says. I have clients who come to me and say, I want my will to say that the life insurance should be used to pay off the house. I'm like, well, who are you giving it to? Oh, I'm giving it to my oldest son. Well, he can do what he wants with it. The will won't matter. It's his. Okay? Same with the beneficiary designations on almost anything else. That includes your IRA, your 401k, your annuities. Those won't pass through probate, so they won't be controlled by your will. There's another type of asset that won't be controlled by your will, and that's anything that's already in a trust. So just what is a trust? I could give you the lawyer answer, okay? It's a contract for the benefit of a third party. Nah. Let's talk about it as a basket, okay? Think about this cup as a basket, and now you've got to squint a little because you're going to think of this basket as a triangle. I know the cup isn't a triangle. There's three parties to this basket, three sides, like a triangle. One side is the person who puts the money in the trust. On documents, you'll hear them referred to as the grantor or the trustor. We're going to call them the trust maker. Another side is the person who manages what's in the basket. Their title is trustee. And then the third job is the one we all want. That's the one who